I know it's we are recording this for the purposes of education, just to let you know. I just have to get rid of that screen there. The Myrna's going to talk to us a little bit about the significance of March 21st, but this year we didn't do our talk on March 21st because Ian Hannah-Mansing was here, and that's quite an interesting speaker for us. So we're here Thursday, but we have also a totally interesting speaker today as well. And before I get started, I'd like to do a acknowledgement of the Indigenous Treaty 7 peoples whose land we are, most of us are either settlers or new inhabitants, and also the Métis Area 3. So thank you very much for my acknowledgement is brief because I can never remember all the different groups. I need to have a sheet in front of me, but it's important to remember that when we have events that we are sharing the land, and they're kind enough to let us do that. And we have two speakers today. The research associate, our research associate from the Research Center, Myrna Tuttle, is going to do a brief synopsis of March 21st International Convention and why we commemorate it and so on. And then our main speaker is Gideon Christian, and Gideon is, I want to get this right, he's a doctor, he's an assistant professor specializing in artificial intelligence and law from the Faculty of Law at the University of Calgary. So I'm interested in that. His current research is very interesting. He's talking about algorithmic racism. So not only do we have face-to-face racism, oh, I shouldn't use the word face, algorithmic racism, which is defined as race-based bias from the use of AI-powered tools in the analysis and data, like with regard to face recognition technology and some of the racism and racial discrimination that arises from that. And people need to be aware of that because it's an increasing use that we have in our society. So look forward to hearing what he has to say and not hearing what I have to say. So I'm going to be quiet now, and Myrna can start.
Thank you, Linda. I'll share my screen now. Can everyone see my screen?
Yes.
Okay, so thank you for everyone for being here. As Linda mentioned, I will just talk briefly about the International Convention on the Elimination of All Forms of Racial Discrimination, which is related to March 21st. So the convention was adopted in 1965, so it's pretty old, and entered into force in 1969. I provided a link here to those who are interested in reading about the convention and the provision of this convention, what it says, and so on. So the convention is one of the oldest conventions to target discrimination. It defines and prohibits racial discrimination and promotes equality among all people, regardless of their race, ethnicity, or national origin. So Article 1 of the convention gives definition of racial discrimination, including distinction, exclusion, restriction, and so on. So the convention is an important international treaty that seeks to promote racial equality and combat discrimination in all its forms. So the prohibited basis for discrimination is race, color, descent, or national or ethnic origin. The convention commits countries that have ratified it, or what we call state parties. So they are committed to the elimination of racial discrimination and the promotion of understanding among all races. So these countries must undertake measures to combat racial discrimination in all its forms. For example, through the encouragement of understanding, tolerance, and friendship among different racial and ethnic groups. State parties are required to provide equal opportunities to individuals who belong to racial and ethnic minority groups. For example, they should provide equal access to employment, education, housing, and other public services. Canada ratified the convention in 1970, and by doing so, Canada acknowledged that racial discrimination should be prohibited and agreed to follow the terms of the convention. So the convention establishes a committee in order to monitor the implementation of the convention. The committee is composed of independent experts who review the reports submitted by state parties on the measures that they have taken to comply with the convention. So they have to submit a report, usually every 4 years, or a brief updating report at intervening 2-year period. And then based on the country review, the committee issues an analysis and a list of recommendations that are specific to each state party. So the committee issues recommendation on how various forms of racism that exist in each country can be effectively eliminated. But unfortunately, despite the existence of the convention and its ratification by most countries, racial discrimination still exists in our societies. So racial discrimination is still a major issue in Canada, despite efforts to combat that. So Canada has a strong legal framework to combat racial discrimination. For example, we have the Canadian Charter of Rights and Freedom, we have the Criminal Code, we have federal, provincial, and territorial human rights statute, and we have the Canadian Multiculturalism Act. But despite all of this, we still have a big problem when it comes to racial discrimination in Canada. And therefore, we all wonder about the effectiveness of the International Convention on the Elimination of All Forms of Racial Discrimination. And from here, I'll leave it to our speaker, Dr. Christian, to give us a better idea about the implementation of the convention. And I just put some info regarding our center here. Thank you.
Thank you, Mayra, for the introduction, and also to Linda. Give me a minute so that I can share my screen with you. Can you all see my screen? Okay. So thanks everyone for taking time off your very busy schedule to attend this presentation today, which is in commemoration of the International Day for Elimination of Racial Discrimination, as was noted in the introductory part of this presentation. The convention aims to eliminate all kinds of discrimination, or all forms of discrimination. Of course, this includes the form of discrimination that didn't even exist when that convention was made, and that is one form of discrimination we are facing today: discrimination by technology. For most of us, or those of us present here who did not live in the era of civil rights movements, we are privileged to enjoy some of the benefits that accrue from that movement, some of the changes that were effected by that movement. And this, of course, include dismantling major overt vestige of anti-Black racism. So gone are the days of white-only restaurants where, as a person of color or a Black person, you risk being imprisoned, arrested or imprisoned for even attempting to sit in such restaurants, even though, as a matter of fact, know whether they will ever serve you any meal. So you can say as our society that we have made huge progress in uprooting elements of anti-Black racism, right? Well, I really wish I was not going to be the messenger of doom today, but I've got some bad news to share. And that is the fact that the progress we have made as a society in the civil rights era is now being subtly overturned by one of the most transformational technology that has ever been invented by man, and that is artificial intelligence. Artificial intelligence is indeed a very broad field of scientific endeavor, but for the purpose of this presentation, we will narrow down to just one aspect of this AI technology, where as a Black person or as a person of color, you should really be concerned about the use of this technology. And that is in the area of artificial intelligence facial recognition technology, or AI facial recognition technology, especially its use in law enforcement. Now, before I go into my presentation, I must confess that this presentation, this research is still at a very early stage. But notwithstanding that, the research has actually revealed some cause or serious cause for concern with regards to the use of this technology. We are today witnessing increasing use of AI facial recognition technology in the public sector, from immigration enforcement to criminal law enforcement, criminal law enforcement, and even much more. AI facial recognition technology has indeed been touted, as a major innovation in the field of artificial intelligence, or AI. However, the fact though is that the use of this technology comes with increasing concern about its ability to perpetuate race-based bias and discrimination against Blacks and people of color. And this is part of what Michelle Alexandra referred to as the new Jim Crow, which was, of course, the title of her book, or by Ruha Benjamin, who referred to it as the new Jim Code. The AI black box has been shown to have, AI facial recognition black box has been shown to have higher tendency to misidentify Black people and people of color. And in some cases, which we are going to be seeing soon, it has actually resulted in their wrongful arrest and detention. Now, it is important to state at the beginning of this presentation that I am a critical race scholar, right? And as a critical race scholar, I use critical race theory in identifying elements of racism, conscious and unconscious, in new and emerging technology. So using this, the critical race theory, my presentation will highlight how AI facial recognition technology perpetuates racism and adversely impacts Blacks and people of color. So the starting point for this presentation then will be to acquaint the viewer here, or the attendees here, or participants, with my view of critical race theory. And this is very important because it is a theory that has been grossly misunderstood, misrepresented to the public. And this is especially the case if your understanding of critical race theory comes from watching Fox News Network and similar news network. So what exactly is critical race theory? Well, critical race theory is an academic and legal framework that was developed by legal scholars in the United States in the 70s and 80s. And these scholars were intent in understanding the lived experience of people of color in a judicial system that presented itself as objective, race neutral, and colorblind. critical race theory was developed in response to the apparent limitation of the traditional civil rights movement in addressing some elements of structural racism. While the traditional civil rights movement in the United States was instrumental in uprooting overt elements of racism, such as segregation, denial of rights to vote, among others, there were many other forms of racism that were buried in institutional practices, in laws, in policies that were not similarly apparent. And these elements of racism surreptitiously fell under the radar of the civil rights movement and continued to thrive in most cases, unknown even to the civil rights activists. So, critical race scholars are of the view that racism transcends beyond individual course of action, that it is deeply entrenched in institutional structures and systems in society, including laws and policies. And such racism is further perpetuated by a social system that tends to portray itself as race neutral, as colorblind, thus further concealing the existence of such racism in the society. Critical race scholars assert that law has been an instrument for perpetuating racial inequality, and that the legal system has also continued to uphold racial hierarchies in the society. My colleague, Joshua Seeley Harrington, a critical race scholar and law professor in Lincoln Alexandra School of Law in Toronto Metropolitan University, sees critical race theory in its plain term as a field of thought that critically and theoretically, that thinks critically and theoretically about race and racism. He went on to highlight three central tenets of critical race theory as identified by race scholars, and those are: one, that race as a social construction, race as a means of subordination, and race neutrality uphold race subordination. So let us break down these three tenets identified by critical race scholars, starting with race as a social construction. Okay, now, many people see race as just a biological characteristic. The color of your skin is a biological characteristic that was transmitted at your biological conception. But to critical race theory, race is not just a biological characteristic, but rather the use of biological characteristics to create a social structure, and then using that structure as a tool for subordination. Now, come to think critically about this. Of all the biological characteristics possessed by humans, why is the color of their skin more dominant than any other characteristic? If we have a social structure that classifies people on the basis of their race, why do we not have a social structure that classifies people also on the basis of their height, their body size, their hair or eye color? Those are biological characteristics too, aren't they? And yet, for many individuals, this particular characteristic, their race, determines their interaction with social institutions, their ability to secure credit from financial institutions, where they live, the value of their property, whether they are stopped or pulled over by police, and if they are, whether they go home alive after that interaction or wind up dead, like George Floyd. So critical race theory has a case for asserting that race is not just a biological characteristic. The fact that the color of our skin plays such a dominant role in our social interaction, notwithstanding the fact that all persons, irrespective of racial ascription or identification, share 99.9% of the same gene. And that fact lays credence to critical race theory's assertion that race is a social construction rather than a biological characteristic. Now, another element of a tenet of critical race theory is that race is a means of subordination. Critical race theory considers race as a means of subordination, and citing back again to the work of Seeley Parenthal, he identified 3 theoretical classifications of racism by critical race scholars. First is systemic racism, which is evident in apparent colorblind laws and norms that disproportionately impact individuals from particular racial group or from particular group characterized by their race. And then second, it's implicit racism, which results from, particular groups being associated with some negative societal trait. And a very good example here I would like to cite in the immigration context, it was evident from a recent report that was released by the Department of Immigration, Refugee and Citizenship Canada, which found a widespread reference by staff of this department to individuals from Africa as the dative 30. The third is microaggression. And this is found in conducts exhibited during the course of interaction with members of racialized group, which unknown to the individual perpetrator actually harms individuals from that racial group. And a very good example here is, for example, asking a non-white person, where are you from, or where are you originally from? As innocent as that question may be to the individual asking the question, the fact though is that to members of racialized group, such question makes them uncomfortable in the space where they find themselves. Then the third tenet that was raised by Joshua Seeley Harrington is that race neutrality upholds race subordination. And this is very important tenet because some people see race neutrality or color blindness as important concept in dealing with racism. So this implies, treating everyone equally without taking into consideration their race as a factor in that treatment. Now, this position may appear just on the face of it. Of course, what could be wrong with, treating everybody equally, you might say. But to critical race theory, race neutrality or color blindness is a part that at best uphold race subordination. The concept of race neutrality or color blindness fails to take into consideration the fact that some racial groups have historically benefited from racism, while some other groups have historically been disadvantaged and continue to be disadvantaged by racism. So the concept of color blindness, race neutrality, meritocracy, treating everyone equally actually works against equitable race-conscious policies and measures that may confer advantage to individuals from racial group that has been historically disadvantaged by racism, especially where such measures are aimed to help address their historical disadvantage. And I would like to illustrate this concept by referring you to the picture on the slide there. So first of all, we start with the picture of inequality. Now, you notice from that tree there that, this is a system that has kind of developed historically to benefit particular individual in that picture to the disadvantage of the other individual. Now, the picture of equality is where the concept of color blindness comes in, treating everyone equally. So that means you give equal ladder to these two individuals to assess the benefits in that system. Now, with that equal treatment, you find out that those who have historically benefited from that social system continue to historically benefit from it, even with that same concept of color blindness or equal treatment. Now we go to the next picture, the picture on equity. So this is where you now have race-conscious policy that are targeted to assist those individuals that have been historically disadvantaged because of racism, in order to be able to assess the benefit that has been historically kept away from them, which is, of course, the adverse impact of racism on them. So this means, of course, designing specific measures to help them. But what is unfortunate today, and what you find today, is that when you have such policies in place, you hear people criticizing it. Oh, it is reverse racism. You are taking away benefit from, white people and giving it to people of color or blacks. But take a look at that picture. Notwithstanding the fact that the individual on the right side of that picture had a higher ladder to assess that benefit, do you think even with that measure in place, they are still benefiting from that system more than the individual or individuals that have historically benefited from the system? So the concept of color blindness, actually, to the critical race theory, that concept of color blindness and race neutrality only helps to maintain the status quo, as you see in the picture on equality, to the disadvantage of those who have been historically impacted and continue to be adversely impacted by racism, while at the same time it continues to benefit those who have historically benefited from the system or from racism. So, as a critical race scholar, I see critical race theory as a theoretical microscopic lens that assists in the identification of implicit racism buried in laws and in social practices that result in unfair outcome or bias to individuals from particular segments of our society characterized by race. And this theoretical lens facilitates the identification, understanding, and remediation of implicit racism buried in the so-called race-neutral laws and policy. So it is the implicit nature of this racism that hid it from the attention of civil rights activists, thus necessitating the need for critical race theory to analyze these laws and policies for the purpose of identification, understanding, and remediation of racism buried in them. So, having explained what critical race theory actually is, and of course you will have realized by now that it is absolutely different from what Tucker Carlson and Sean Hannity must have told you it is. So using this theory to study new and emerging technologies will reveal how these technologies reinforce implicit bias and racism against individuals from certain group characterized by race, of course. So I will use this theoretical lens to analyze one of the most transformative technology ever invented or developed by man, that is artificial intelligence, but more specifically, facial recognition technology. And I will start this analysis or this technological analysis with algorithm and bias. So, and when I talk about bias here, I'm specifically referencing or referring to racial bias. Okay, so there are many ways that biased outcome will result from AI tools. First is where an AI tool, artificial intelligence tool, is deliberately designed to generate biased outcome. Now, this is a very rare, but if it exists, then of course a clear case of explicit bias resulting from bad faith software engineering. So this is a rare case. We're not gonna spend time talking about it. But the second and third situation is the one that will concern us. And the second situation is where biased data is used to train a computer algorithm to make prediction. And the third situation arises where an AI tool trained on data that are responsive to unique factor or factors in a particular environment are now deployed for use in a different environment. So the second and third case or cases will generally result in implicit bias. A research study undertaken by a US non-profit newsroom, ProPublica, revealed the tendency of AI criminal justice risk assessment tools to perpetuate existing racial bias and stereotype in the society. And that study, of course, was that study focused on recidivism risk assessment tool, an AI-powered recidivism risk assessment tool known as COMPASS. And this is a tool that is used to predict the likelihood that individuals in the criminal justice system will reoffend. Such prediction is important, of course, for bail determination and for sentencing. COMPASS is one of the most widely used AI risk assessment tools in the criminal justice system. And this study by ProPublica, in addition to raising some doubt about the accuracy of the prediction made by these AI tools, that study even raised some even more serious concern with regards to racial bias that was evident in that tool. And this was evident from the fact that the tool was predicting individuals, Black individuals in the criminal justice system, as being more likely to reoffend twice more than their white counterparts. And the accuracy of that tool was even challenged when it became evident that Black people who were predicted to be high risk of reoffending did not go on to reoffend, while white people who were researched, who were predicted as less likely to reoffend, actually went on to reoffend. So that bias along racial line was evident from ProPublica's analysis of this AI-powered tool. And that analysis from Publica, of course, goes further to substantiate the fact that some AI tools actually have the tendency to be biased against individuals from minority communities like Black and people of color. Now, the tendency of results from AI tools to be biased against people of color has been referred to in my research as algorithmic racism, and which I define as a systemic race-based bias arising from the use of technology in the analysis of data and decision-making, resulting in unfair outcome to individuals from particular segments of the society, of course, characterized or distinguished by their race. So in the context of facial recognition technology, which is, of course, the subject matter of our discussion today, algorithmic racism, in the context of facial recognition technology, algorithmic racism may result from disproportionate representation of Black faces or faces of people of color in data used to train the AI algorithm. And what is the impact or the results of this disproportionate representation? Now, this is a sample illustrating the accuracy rates of major facial recognition softwares in the market today, developed by, of course, commercial corporations or commercial developers. Now, you see here accuracy rates on the basis of race and gender. Almost all these types of AI facial recognition technology have their highest accuracy rates in identifying white males, lighter skinned males, 99% accuracy rates. And the lowest accuracy rate comes with the identification, and this is important, identification of Black or dark-skinned women. In fact, IBM software has about 34% error rate in identifying dark-skinned women, even though it has 99% accuracy rate, which is just 1% error rate in identifying a light-skinned male or white males. So what is the impact of this accuracy rate across racial and gender divide. And now this is where we are going to now turn on to see real life cases of adverse impact of AI facial recognition technology on individuals on the basis of their race. First, we start with the example of Robert Williams. In January 2020, Robert Williams, a young Black father living in a Detroit suburb, was arrested in his driveway in the presence of his daughter and his wife. He was arrested by Detroit police officers. Robert's alleged crime was shoplifting. The fact, though, was that Robert never lifted anything from any shop. Rather, the Detroit Police Department's use of AI facial recognition technology erroneously matched Robert's face to that of the actual perpetrator of the crime, the shoplifter, resulting in Robert's wrongful arrest and detention by the Detroit Police Department. Robert's case represents one among many other cases of Black men who have been wrongly arrested and in some cases falsely imprisoned for crime they never committed because of false identification by AI facial recognition technology. And this problem was not just limited to Robert alone. Another example, Michael Oliver. Michael Oliver is a Black man from Detroit. He was arrested and charged with felony larceny after facial recognition technology falsely identified him as the perpetrator of the crime. Now, the picture you see there on the slide, the guy or the gentleman in red shirt was actually the perpetrator of the crime in question. That was a cell phone video that was taken of him in the course of his criminal act or conduct. AI facial recognition technology that was used matched the perpetrator to Michael Oliver, the gentleman on black shirt, right? Oliver was arrested, Mr. Oliver was of course arrested for the crime. And he spent 9 days in jail. The charges against him were dropped after his lawyer got disclosure from the prosecution, and they matched the picture of the perpetrator with the picture of his client. And if you match those pictures, the difference is obvious and latent. The perpetrator is much darker skinned than the individual that was arrested, that was Michael. If you look at the hand of the perpetrator, you'll see that there is no tattoo. And that is different from Michael, who has tattoo all over his hand. So when his lawyer presented these obvious differences to the prosecutor dropped the charge. And this was after Michael has spent 10 days in jail for a crime. Has spent some days in jail for a crime that he never committed. Another example. Okay, sorry. Yeah, I'm getting a message here. I should increase the volume. Can everyone hear me very well? Is my audio?
Yes, the problem's been resolved.
Okay. Okay, let me go back to the screen. Yeah. Okay, can you all see the screen now? I mean the slide back. Okay, so where are we? So yeah, we're talking about the third example. That was the case of Mr. Nija Park. Nija Park was a black man from New Jersey who was wrongly arrested and charged with shoplifting after facial recognition technology incorrectly matched him to the picture of the perpetrator. Now, I must actually emphasize here that shoplifting actually is the list of the crime he was charged with, because after the perpetrator was being chased by the police after the shoplifting. So in the course of evading police, more serious crime than shoplifting actually occurred. And this crime include unlawful possession of weapon, resisting arrest, and aggravated assault. Right. Now, facial recognition technology matched the picture of the perpetrator in a fake ID that was left at the scene of the crime. It matched the picture of the perpetrator with that of Mr. Park. Mr. Park was arrested and jailed for the crime. He spent 10 days in jail. While the case was pending, the prosecution offered him a plea deal to serve 6 years in jail for a crime he never committed. And based on his previous criminal record, he was on the verge of accepting the plea deal to serve 6 years in jail for a crime he never committed. What actually changed the situation was that while the case was ongoing, he was able to find a transaction receipt from Western Union, which showed him to be 30 miles away from the scene of the crime at the same time the crime was committed. That was a perfect plea of alibi, which proved his innocence beyond doubt. And that was the basis on which that charge was dropped. If not for that receipt, Michael would have been voluntarily pleading guilty to a crime he never committed. Sorry, not Michael, Niger would have been voluntarily pleading guilty to a crime he never committed and serving some 6 years in jail, all because of misidentification or faulty identification by facial recognition technology. One more example. Judge Rundle, 28-year-old Black man from Georgia, resident of Georgia. He was arrested for the theft of some luxury purses in Louisiana after yet a facial recognition technology matched his face to that of the thief. The fact, though, which is very concerning about this case, is that Randall has never been to Louisiana where the crime was committed. In fact, he was living 2 states away from Louisiana. So he, of course, spent about 6 days in jail before he was able to clear his name. And no thanks to facial recognition technology. Now, let's talk about, all the examples we've considered so far has been, US and not Canada. In Canada, let's come back home now to the Great White North, Canada. In Canada, for a known period of time, AI facial recognition technology was deployed and used by various law enforcement agencies in Canada, including the RCMP, and of course, the biggest police department, Toronto Police. The secret use of this AI facial recognition technology sparked an outrage when it became public that these public sectors were using the controversial AI facial recognition technology. And this resulted in an investigation, or many investigations. There was one by the Office of the Privacy Commissioner. There was even a parliamentary committee hearing on this police department's use of Clearview facial recognition technology. But it is important to note here that the outcry against the use of AI facial recognition technology, and I'm saying this from a critical race scholar perspective, that the outcry against the use of this technology by the Canadian public was not because the technology has higher accuracy rates in identifying or recognizing, has higher error rates in identifying or misidentifying people of color. The outcry against the use of Clearview facial recognition technology was based on the unethical and indeed unlawful method that was adopted by the developer of this technology in scrapping the internet for people's photo without their consent and using these photos to build their database. That was the basis of the outcry against the police department use of Clearview facial recognition technology. So aside from the privacy issue, which was of course concerning to the Canadian people, Black people and people of color should even be more concerned, not just about the privacy issue arising from that technology, but even the high error rates in identifying individuals from that racial group. So unlike US, in Canada, we do not have any publicized case or cases of Black people being misidentified by AI facial recognition technology resulting in their forced arrest. And I cannot tell you that this is the case because that never occurred. It is important to know that the police use of this tool in Canada was clandestine, it was secret. So even if we have cases of, or actual cases of arrest arising from misidentification of people as a result of police use of this tool, the fact is that we would not have known because it would not have formed part of police disclosure in the course of their disclosure. After all, they were using these things unlawfully. So you should also expect that the results from their unlawful use will not be in the public domain. So at this point in time, maybe I may probably kind of, at this point, tell you how I got into this research or what actually precipitated my research in this area. Last year, I began conducting research on AI facial recognition technology. They are used by law enforcement agency. I began that research after I joined the Calgary Police Service CPS Technology Ethics Steering Committee. The purpose of my conducting that research was to help the police department, the CPS, to develop ethical guide for their use of artificial intelligence technologies in community policing. So, but soon after I started this research, then came what I refer to as distraction, distraction in quotes. And that distraction came from a non-related research that led me to reading the case of Barry and Canada, Citizenship and Immigration Canada. I will provide you with the facts of that case, which of course you can see on this slide here. Barry and Citizenship Canada, or Canada, involved two Somali women who made a successful refugee claim in Canada. After their successful refugee claim, which means they were declared to be refugee, the Refugee Protection Division, RPD, accepted their claim of refugee status and conferred that status on them. Soon after that was done, the Minister for Public Safety brought an application before the RPD, the Refugee Protection Division, seeking to revoke the refugee status of these women or to vacate their refugee status on the basis that they misrepresented their identity as Somalis when in fact they were from Kenya. So the minister's evidence included evidence alleged by the applicants in this case to come from Clearview facial recognition technology, which matched these two Somali women with pictures of two international students who IRCC claimed were of Kenyan citizenship. So the Refugee Protection Division revoked the refugee status of these women, which of course resulted in judicial review of the decision by the board. One of the issues that arose in the judicial review proceeding was whether the minister used facial recognition technology, that is the Minister of Public Safety, used facial recognition technology in photo comparison of these women with the other Kenyan nationals they were said to have, to be emerged. Now, this is important. The Minister of Public Safety in this case was neither transparent nor forthright with regards to the use of the facial recognition technology. That was one issue they avoided both at the RPD and the federal court during the course of the judicial review. Rather than disclosing that information, they asserted that under Section 22, subsection 2 of the Privacy Act, that act provision allows a law enforcement agency to protect details of their investigation, that is to protect their investigation technique, which I think is a very wrong and erroneous assertion. And why do I say that? Now, let me illustrate this. I mean, I believe everyone here knows, among other things, that police use undercover agents as investigation technique. I mean, we don't have to be career criminals to know that they do that, basically using undercover agent. So the fact that police uses undercover agent is not protected by investigation, it's not an investigation technique protected by investigation privilege. So if I ask, I'm a defense counsel in a criminal matter, I ask the police, did you use an undercover agent in investigating this matter? Disclosing that information would not result in any loss or disclosure, disclosure of investigation technique, because it is common knowledge that that is an investigation technique used by the police. Whether they use it in this case has nothing to do with protection of that technique. But it is different if, as a defense lawyer, I ask the police officer, I need the identity of the undercover agent you use in this investigation. That is one situation that will be protected, by that provision. So asking or requiring the minister to disclose whether they use facial recognition technology is not protected by the Privacy Act Section 22(2). However, that would be different if the question is, I need the source code of the facial recognition technology you guys are using in your department. That will clearly be protected because disclosure of the source code will, of course, result in reverse engineering, which will, of course, compromise their use of that technology. So in this case, the assertion of investigative privilege by the minister was wrong. However, the Refugee Protection Division at the level of RPD accepted the minister's evidence about the photo comparison, but rejected the applicant's request to compel the minister to disclose the source of that comparison, that is whether they use facial recognition technology in making the comparison. So Justice Gao at the federal courts accepted, during the course of the judicial review, accepted the applicant's position that facial recognition technology was used in the photo comparison, and that the blanket reliance by the minister on the Privacy Act, Section 22, subsection 2 of the Privacy Act was misplaced. To cite Justice Gao, she said, I quote, that the applicant submit that facial recognition software is an unreliable pseudoscience which has consistently struggled to obtain accurate results, particularly with regards to Black women and women of color. And of course, she went on to cite the high error rate with regards to the use of this tool on Black women compared to white male. That is about 34.7% error rate in Black women as compared to error rate of 0.8% on lighter male faces. So the question then is, if this tool or this technology has this high error rate, 34.7% in identifying Black women or darker female faces, how could the Minister of Public Safety, in the light of this scientific research, still use this technology or deploy this technology in identification of these particular individuals who come from a racial group that is highly and disproportionately impacted by the use of this technology? So reading this case was an eye-opener to me, because that was when I even got to realize for the first time that Immigration, Refugee and Citizenship Canada and CBSA were actually using facial recognition technology. And that was very concerning, So that was the detour. My research quickly made a switch, and I kind of started looking at the use of this technology by these two government departments. And the more I look, the more I saw. Let me give you another example. So Barrier in Canada was decided in summer of 2022. So after reading this case, I tweeted this case on my Twitter. After tweeting this case, I got a private message from an individual I don't know. His English was not the best, but the concern he raised caught my attention. He sent me a private message letting me know that he saw my Twitter that Canada Border Services are seeking to kick him out of Canada because they match his face to some other person. He left his phone number, inviting me to call him. I mean, I get a lot of such messages on my DM. Some of them I don't even bother replying, but this one was serious because it's something I'm working on. So I decided to give him a call. So in the course of my interaction with him, I now got to realize that his case is actually in court already and that he was represented by a lawyer. So that was where I ended the conversation. I told him, okay, since you're represented by a lawyer, I mean, ethically, I'm not supposed to be carrying a conversation with him. So I told him, I need your lawyer's number. I need to call your lawyer and speak with your lawyer about your case. Because of course, the lawyer will be in a better position to provide me information about the case than the client. So he sent me the lawyer's number. I called the lawyer, and the lawyer was based in Toronto. I began speaking with the lawyer. So in the first minute of my conversation, I introduced myself to him. I told him, look, I'm a law professor in University of Calgary. I'm calling from the University of Calgary Law School. I specialize in artificial intelligence and law. And this is what has happened. I got a call. I spoke with this person who happens to be your client with regards to this matter. And he told me that you are his lawyer. So I cut the conversation short. And I wanted to have this conversation with you. I mean, without disclosing any solicitor-client privilege information, if you could provide me general information about this case, I'll be very interested. He was like, no, I'm not even the person you're supposed to be talking to. I'm just representing one client on issue relating to the use of this technology. Actually, right now, I have a lawyer in my office who is representing many clients facing this situation. She is the person you should be talking to. She's just visiting my office right now. I was like, wow, what a coincidence. Please, I would like to speak with her. So he invited the lawyer. We had a conversation. And that's when I got to realize that this is a huge deal within the GTA area. She made me to realize there are many cases right now in the GTA area where CBSA is using this, having used this technology, is now bringing application to revoke status of individuals who have made successful refugee claim. And you know what got me more worried about it? Most of her clients, and not just her, but even other lawyers she knows, are individuals from the Somali community. So we carried on that, we kept in touch. For me, of course, to follow the developments with regards to the cases she was handling. But after that conversation, January the following year, then came another case, still on use of this technology in the immigration context. That was the case of Adul and Canada Citizenship and Immigration. Yet another Somali woman, she made a successful refugee claim, just like the others, before the Refugee Protection Division. After the claim, the minister appealed the decision, RPD decision, on the ground that the applicant's face matched another individual in their database who is from Kenya. So the applicant, of course, in this case, argued that the minister must have used Clearview AI technology to match her face with millions of other faces on their database. Now, there was a problem with this case, and that problem was what made it different from the Barry case we've considered earlier. In Barry, the applicant made a consistent effort for the minister to disclose the technology they used. That effort was rebuked by the minister and by the RPD. They weren't able to get access to the technology or to the information, whether they used the technology. In the case of Adel, the mistake was made here was that they built their case on speculation that, oh, Immigration receives millions of applications every year with millions of faces. That it's not possible for them to manually go review all these pictures. So they must have used technology. They must have used Clearview AI technology. That is speculative. It was not founded on any evidence by the applicant, and they made no effort to compel the disclosure of evidence from CDSA or Minister of Public Safety. So the minister, on the other hand, traditionally, as they often do, refuse to disclose whether they are using AI technology or not. Rather, they denied using Clearview AI, which is very tactical because Clearview facial recognition technology is not the only facial recognition technology out there. So if the minister deposes that they are not using Clearview facial recognition technology, that may be true. It's possible they're not using Clearview. Maybe they are using IBM or some other software. So they denied using Clearview AI. They rather asserted that they used traditional investigative technique. Traditional investigative technique. What is traditional investigative technique? They didn't say. They just used that catchphrase to, of course, continue their lack of transparency with regards to the use of this technology. So the federal courts, of course, this paragraph 35 of the decision highlighted what was problematic about this judicial review application on the part of the applicant. The court noted that while the weakness of facial recognition software are common knowledge, the applicant's argument is undermined by the fact that she did not seek a direction for disclosure from Refugee Appeals Division, right, on the method or processes used, but proceeded to make her appeal argument based on assumption without any evidentiary foundation that such software had been employed. This was merely speculative, particularly in the face of the respondent's uncontroverted assertion that an exhaustive search had been conducted using, in quotes, traditional investigation technique. Whatever those techniques were, no inference can be drawn that they included facial recognition software in the absence of supporting evidence. So that was the weakness of that case. But what is more disturbing about all these cases is the consistent refusal of the Minister of Public Safety to disclose whether they are using facial recognition technology or not. I think that's an obligation they owe to the Canadian public. If they are using that technology, Canadian public, for the sake of transparency, should know whether they are using it or not. Then if they are being secretive about it, then there is cause for concern. And that cause for concern should affect everyone, whether you're a Black person, person of color, or white person. But most importantly, as a Black person or person of color, you should be more concerned because of the high adverse impact that technology has on individuals from that racial group. Yet another case. And if you felt the two cases we've discussed so far are disturbing, this one is even more. The case of AB and Canada, Citizenship and Immigration, this relates to a Black Cameroonian woman who made also a successful refugee claim. Years after her successful refugee claim, she visited the Ministry of Transportation in Ontario to have her picture taken for her driver license. Now, I have visited the Ministry of Transportation in Ontario to have my picture taken on many occasions when I was resident there. Even as a lawyer, my understanding is that the essence of taking that picture is for them to affix it to my driver license. And I believe every other person here will probably presume the same. But what happened was that after MTO took the picture of this woman, without disclosure or even any disclosure to that effect, that they were using facial recognition technology, they scanned her picture on their database. And that facial recognition scan matched her picture with some other person. Now, based on that information, NTO passed her information to another government department, IRCC. And based on this information, IRCC successfully brought an application before Refugee Protection Division to vacate the refugee status of this woman. Now, the concern here, as a critical race scholar, my concern here is not whether these two individuals match or not. My concern here, as a lawyer and as a critical race scholar, is the clandestine use of these tools by various government departments. And that should be concerning to everyone. Yes, the clandestine use will have resulted, in their being able to successfully determine individuals that were kind of trying to be fraudulently or defraud the system. But the question then is, for these few individuals we know or that might have been caught in the act, how many other individuals might have been erroneously matched using that technology? And that should be more concerning to you as a lawyer or to me as a lawyer, because as a lawyer, we often say that it is better, to discharge one guilty person than to, it is better to discharge 10 guilty persons than to convict one innocent person. So our concern with regards to the use of this technology is not its ability, just its ability to, catch individuals who are wrong in the act, but even more concerning, those innocent individuals who may actually be falsely identified by this technology that has over 34% error rate in identification of individuals from this particular racial group. So from what we have seen so far, facial recognition technology has a very high error rate when it comes to identifying individuals, from racial group like Blacks and people of color. What could be the reason? Well, I'm not a software engineer to determine or to analyze this technology to know what actually is the reason. But generally, the reason for that error rate, of course, normally arises. We talked about algorithm and bias, of course, when individuals from particular racial group are disproportionately represented in the training data used to train the algorithm. It is a known fact that IT field is a predominantly white male field. So individuals designing this technology are predominantly white male. Where you use predominantly white male faces to train this technology, it will have an excellent near perfect accuracy rate in identifying white male faces. And it does, over 99% accuracy rate. When individuals from other groups are not adequately represented in the training data used to train this technology, the impact is going to be there. We are not saying that individuals who develop this technology set out to be consciously or deliberately biased or racist. But racism is not about intention. There will be racism arising from even unintended acts, right? So far, facial recognition technology, because of the high error rates it has with regards to identifying faces of individuals of color and Black individuals, that high error rate, of course, makes it a racist technology because of the bias against individuals from this particular group. So in conclusion, in Judeo-Christianity, we learn that man was created in the image of God. And in AI, facial recognition, in AI, we learned that facial recognition technology was created in the image of the white male. And until that technology evolved to accurately reflect the image of Black people and people of color, it will remain a technology that is entangled in a complex web of racial bias. So for now, that technology may adequately and appropriately be used in identifying white male faces. But that technology needs further training improvements before it can be rightly deployed for the purpose of identifying faces of individuals or darker skinned faces. Thank you very much for your time in attending this presentation, and this will mark the end of my presentation. I will be very happy to take any question from the audience. Thank you.
Thank you so much, Gideon. I have a million questions, and I don't want to hog the floor. So I do have one, and then I'll open it up to everybody else. Is there any involvement in these cases of complaints made to the Privacy Commissioner?
Thanks, Linda. The only complaint I know of now was the complaint that was made in relation to Clearview AI, when Clearview AI scrapping of people's picture on Facebook and social media and using it to build their facial recognition database. Of course, when it became public, Privacy Commissioner Office was flooded with complaints from Canadian public, and that resulted in series of investigation. There were also other complaints that were made to some other provincial information and privacy commissioners. And I'm very much aware that some provinces actually embarked on their own separate investigation of Clearview AI. So those are the ones I'm aware of for now. And like I noted, the concern arising from Clearview AI was basically on privacy issue, and
yeah.
So that is the one. Those are the ones I'm aware of now, and I do strongly believe that as some issue relating to this technology becomes obvious and public, I think there will be more complaint, not just on the privacy aspect of it. Actually looking at the possibility of complaint to a human right complaint arising, because this clearly falls within the context of human rights, where individuals are falsely identified by this technology, resulting in their arrest, and especially with regards to individuals who are most adversely impacted by the development of this technology. So I think I see that in the pipeline, even though such complaint hasn't arisen yet.
I can talk to you off camera sometime. There have been a couple of cases at the commission regarding not machine identification, but improper identification and arrest of somebody who wasn't involved with a crime in Calgary, actually, maybe about 10 years ago. So
Okay.
I can talk to you about that, but the outcome wasn't in my favor. I wasn't happy with the outcome. But the other thing is, I'm thinking about the lady with the license. I'm sorry, I've have a million questions. The lady with the license, getting her picture for her driver's license.
Yeah.
The thing is, a lot of times the privacy is not going to help, because it's going to say somewhere in the fine print that you consent to the use of that picture for whatever. And if you want your driver's license, you're going to have to get your picture taken. And so it's kind of a false protection, right? I mean, the Privacy Commission's got to get involved in that.
Yeah, that's a very good point you raised, Linda. So my knowledge of that case for now is limited to what I read in, in that case law. So right now, I actually have an ATIP request pending in that office, because there is still much out there that needs to be known aside from what you had in the case law, and which is what I'm kind of trying to find out, among other things, whether Ontario or MTO Ontario has any agreements with IRCC to share information. If they don't have that agreement, even a disclaimer or a fine print does not authorize them to transfer that information to another government department. So that's one information I'm seeking to access from the department, to know whether that agreement was actually in place, which authorized them to transfer that information. Because if that agreement is not in place, then this is a clear case of breach of the privacy rights of the individual involved. If they have an agreement with the federal government or IRCC that's okay, we can share information, then that may probably justify the transmission of that information to the individual. But it's very concerning, you know. Like I said, if I walk into MTO office to have my picture taken for driver license, the last thing I will have in my mind is that, okay, they're going to run this picture using facial recognition technology. No one will ever think of that. If I had not read this case, I wouldn't have any way known that that even happens.
Exactly.
So if you're applying for driver license, now you know.
Well, and the lady, like the woman in that case, she would have it was settled. She was given refugee status, and it was a long time ago. So that why would you ever consider that this is going to come back up to haunt you? It's awful. So there's a question in the chat.
Yeah.
It says from Namrata Sharma. Thank you, Dr. Christian. A study I really like on this subject is gender shades. And then there's a link to gender shades. One of the graphs from this presentation seems to be similar to their data. And this study includes a recommended data set for facial recognition technology. Oh, thank you very much, Namrata, for that. It's in the chat if you want to look at that link.
Okay, thanks, Namara. I think I also see another question from Avinash.
Abhinash.
Yeah, so there's another question.
Go ahead. Please go ahead.
Okay, so I'll read it. Since eyewitness accounts also tend to be highly unreliable and prone to racial bias in many cases, what are your thoughts on which tool should be used, facial recognition versus eyewitness statement to identify someone?
So for facial recognition, well, I mean, you rightly noted both of them have their own problems. For facial recognition, I mean, this is my position with regards to use of facial recognition technology is this. Science and research is out there that this technology is near perfect in identifying white male faces. There's no doubt about that. In fact, in all my research, I have not seen any case where they say, oh, the technology falsely matched a white male to another person. It's not that that doesn't exist. Remember, it has 99% accuracy rate. So that means for every 100 white male face, it's likely to get one wrong. And even that one is problematic and all. But that's, you cannot compare to another situation where of that 100 people, 35 of them will get it wrong with regards to 35. That is high enough. So for now that the technology is very, very good with regards to use on an individual from this particular demographic, lighter male, why not restrict its use there? Mm-hmm. This is an evolving technology. Probably someday it's going to evolve enough to have that 99% accuracy rates in identifying dark female faces. But even among the cases where it has 99% accuracy rate, I am strongly of the view that facial recognition technology should not be used in isolation. It should just be one among other evidence. In the cases we analyze in US, I mean, these are cases where it's obvious that these individuals were not really involved. They weren't really the perpetrators. You know, think about the guy with tattoo. It's very obvious. If the individual who sought that arrest warrant has taken time to say, okay, now facial recognition technology have matched this guy. Let us see if we can get some other evidence to actually connect him to the crime before going to arrest him. That will have helped rather than scanning through a database. Here is a match. Okay, get arrest warrant. Let's go pick him up. So what I'm saying in essence is do not use any of these tools in isolation. Make sure where it involves individual rights, make sure there are other collaborating evidence to support the output from the facial recognition technology.
Yeah, that absolutely makes sense. And in the meantime, we need to hire a lot more IT experts who are women of color.
Yep. Absolutely.
So they can do a better job. Any other questions?
So now there is one question I was, okay, I think there was this maybe question I'll probably bring up here. I think this was a question that was asked by someone in the, Linda, remind me the presentation some weeks back by the, is it the BC Civil Liberties or the International Civil Liberties? So I can't remember but we had a, something on facial recognition some couple of weeks ago where somebody asked, okay, if this, what's the positive of the technology? Basically, what is the good use the technology could be put to, right? Yes. So, and that's a very important question because, I mean, as bad as the technology might be with regards to its use in, especially in individuals of color, the fact is that there are actually some good use this technology could be put to. It's not that evil technology after all. You know, in many organizations use facial recognition technology as a part of their cyber protocol, you know, to restrict access to authorized databases and facilities. So basically, if you're a staff in such organization, before you can access the company's computer database, they have to use facial recognition technology to match your identity with what they have on file. So if I'm able to, if I'm a hacker, I hack into, for example, FBI database. So one of the steps, you know, that could be required before I can access the database is for it to match my face to maybe staff of the organization. That's one positive use you can make of facial recognition technology. Some properties, even physical properties, before you access them, you know, as like corporations, you are required to use facial recognition technology to restrict individuals coming in there. Another good use, of course, in area of war crime, you know, in Ukraine right now, facial recognition technology is being used to match pictures taken from drone to identify Russian soldiers who have been engaged in war crime. So the pictures taken by these individuals using drones in the battlefield is used to scan the internet and social media profile. And in many cases, it has identified Russian soldiers that were engaged in war crime against Ukrainians. So there are many benefits facial recognition technology could be put into. So I'm not anti-facial recognition technology, even as a Black person, person of color, and as a critical race scholar, I'm not anti-facial recognition technology. My concern is that we need to develop appropriate framework for its use, develop the technology in such a way that it could be accurately used in society so that we don't end up, you know, carrying with us those elements of racism in the real world and then transferring them to this technology. We will not be making a progress by going down that road.
It's absolutely true.
Lindsay, I believe you had your hand up.
I did. Thanks, Gideon. And you kind of started. I kind of felt like your answer sort of responded to mine, but mine had to do with Clearview and why they would be so hesitant to say we relied on a particular technology and why they're so lazy that they don't supplement a technology with something more reliable. So I think you kind of went there, you know. Is there some magic to a technology that you say, I've got a technology, I can't possibly look at the pictures myself? I just don't get it. Or the women of color that Linda's suggesting we should definitely staff all these offices with, critically look at all these pictures and go, that is not the same person.
Yeah, you know, I don't know if this is a case of bureaucracy or maybe a case of lazy public servants who just use go for the low hanging fruits, because I mean, I see kind of continues to go back to that case of, I think that's the case of the US case, Michael Oliver, because it's so obvious comparing those two pictures, you can tell. So the question then is, why could somebody not just spare extra minutes after these facial recognition tools have made? Why could somebody not even spare a minute to compare those two pictures and then come to a conclusion? Is it the case of being too lazy or being so much in a hurry to take people down because you are perceived to be criminal because of the stereotype associated with individuals from that racial group. So, like I said, this tool still has a long way to go before we can safely deploy it for use in racialized community. And if we insist on using it, then there should be there should be structures in place, to get those collaborative evidence to make sure you're backing up with what's the tool, the conclusion made by the tool. And what continues to surprise me is, the consistent approach towards secretive use of this technology, especially as we have seen from these immigration cases. Why can't the Minister of Public Service come out and say, yes, we are using this technology? I mean, I understand their concern, maybe if it's made public there, it's probably going to impact their use. Maybe individuals who are intent in committing crime will no longer come forward because they know they'll be identified, which would be good, of course, right? Which is good. I do not believe as a society our rights are protected when government departments resort to secrecy and lack of transparency. Yes, the most secure society in the world, probably North Korea, is very secure because of transparency, but that is not the kind of society we want to be. And that is why most of us are not living in North Korea, we're living in Canada, because we expect a level of protection and transparency from the government. So it is very important, that transparency should be enshrined. And that is one particular area of my interest in this research. So I've done a couple of access to information requests, which of course I know I may probably not be assessing in the next 1 year because I'm going to get pushed back either by unreasonable extension on that disclosure, which may eventually end up with a complaint to the Information and Privacy Commission and then another hearing and maybe judicial review. But I think the essence of, digging deep into a situation like this is to make sure that we have a society where our right is protected and not a society where public servants choose to hide things they ought to, individual members of the society need to know.
Sorry, I have to keep my thing on mute for a second, but I have another question. Oh, there. Now this is going to sound political. It's not meant to be political, but don't you think there's even racial bias, racism based in the decision of who they're gonna forward stuff to the refugee people? What I'm saying is, for example, Somalia, there's a lot of violence and problems there. So maybe there's an underlying fear that people who are coming from Somalia are, undesirable. I hate to use that word, but you know what? Dangerous. And so there's an inherent bias even in the ones that we decide to go further and do the checking on. Does that make sense? Did I say it right?
Yeah. So, when I followed up with that private message I got on Twitter, spoke with that lawyer and then the second lawyer, and when she now raised that issue that most of the people that have been targeted using this technology are Somalis, I didn't take that. Well, I took it serious, but not as much as I did when I kind of dig further. I'll probably think, probably she said that because most of our clients are Somalis, but then came of course, Barry was 2 Somali women. Then you now have the case of Ado, which was the second case I came across, yet another Somali. I was like, okay, what's going on? So I kind of began to do some digging, and I'm beginning to suspect that maybe the reason why they target Somalis, it's because Somalia has had a failed government since the 90s. So it's so difficult for individuals coming from that part of the world to have like a government ID.
Exactly.
So could this be the reason why they are targeting Somalis? So, I mean, I can't say, I don't know.
Yeah.
I was more like playing the government lawyer or government advocate, of course, being at the other side of the fence. That is the only reason I could think of. Maybe there might be some other reasons among individuals that make this decision at public service. I don't know. And I probably might not know the reason. If they are unfairly targeting members of the Somali community, then that's, of course, a very serious case of, racial discrimination. But I do not have any evidence to establish that right now as to go far as to say, okay, it's a case of, racial discrimination. But that notwithstanding, what I keep saying is that whether it is the Somalis that are specifically targeted or not, the fact is that whether they are Somalis or they are Kenyans, they are dark-skinned individuals and they fall under the group that are adversely impacted by the use of this technology, irrespective of their nationality.
Yeah, it's like just another layer of possible of racism in the institutional aspect. That's all I wanted to raise. There's a question in the chat by Gideon. Sorry if I got your name wrong. Is there regulatory oversight to supervise or audit the data set used for these technologies by the ministries that deploy them?
Okay, I will probably take that question at general and specific. Generally, the government have, use of AI by the government department is subject to their AI impact assessments. So that is done. How much that goes into oversight, into data sets used, I would say not quite much, because in most cases, the government department themselves do not develop these technologies. Private corporations develop it and then sell it to the government. And I would even go further to say that even the government officers using it don't have any idea as to what data set was used in developing the technology, because those are proprietary information, which is not even disclosed to the licensee. When you license it as government department, you're only limited to use. You're not, allowed to reverse engineer it to know the black box or what is contained in the black box. That would be clear case of IP infringement. So when it comes to oversight over the data, only the commercial developers actually know much about that and not the final user.
Thank you. There's another question from one of my board members, Travis. Hey, excellent presentation, Dr. Christian. Thank you. Can I ask, who are your main theoretical influences in the way you approach your work? In addition to those cited in your talk, which books or scholars had the biggest impact on you?
Okay, good question.
Give us a list.
So there are these two publications here. There are many. There are many. So I'm not paid to advertise any book here. The New Jim Crow by Michelle Alexandra. It's one good read. There are a lot of them. There's Algorithm of Operation by Nobles, Automating Inequality. So I don't know which I can give you a lot of lists. But one thing I find out in the course of my research, my research is race focused. It's focused on race, right? Even though it's AI and technology. AI and technology is a broad field. Now, I try to narrow down on unique issues. Of course, the idea is, how do these new and emerging technologies adversely impact individuals on the basis of their race? And I find out that one theoretical framework that would be very useful to me in making this analysis is critical race theory. Because what critical race theory does is to, okay, wow, this thing looks so race neutral on the face of it. It doesn't discriminate between black person or white person on the face. Yeah, But what critical race theory does is, critical race theory is like a lens, right? When you pick up an object, you might look clean on the face. I mean, when you take a lens and look at it, then you see the impurities buried deep inside, which you cannot see looking at the face. That's exactly what critical race theory is. Even race-neutral laws that exist on the face to appear race neutral, when you use critical race theory to analyze them, including their implementation, you kind of begin to see that, okay, I think there are elements of racial bias in it, which you could not see, looking at it on the plane. So that's how I got attracted to critical race theory. And I mean, for me, it's still a new area of research, but I kind of tend to find it very useful in the course of my research and analysis. And like I said, in most of my presentation, I kind of first of all start by letting the public know, okay, this is my idea of what critical race theory, especially if people see it as what kind of Donald Trump referred to it as a toxic propaganda. It is not what Fox News and their agents tell you it is. There's difference between politicians trying to use it to achieve their political aim to create racial division and what actually it is. Critical race theory was developed by Black legal scholars. So if you really want to know what critical race theory is, don't listen to Sean Hannity and his likes in Fox News. They know basically nothing about critical race theory. Read publication by Black legal scholars that will tell you what critical race theory is, and you'll be amazed to know that it is clearly different from what this politician kind of tell you it is, or it's a theory that kind of holds every white person responsible for the atrocities committed by their forefathers. Wrong, very wrong.
Yeah, that's awesome. Thank you. And it's something that I found that diagram, that visionary diagram with the trees, very interesting. I want to think about that some more. I tend to focus a lot on equity in my educating people, and so that one.
Okay.
I like that. And I want to think about, the difference between equity and justice, and I get it from the picture, but think about the implications of that. I think that's really interesting. Are there any other questions? I can't tell. I find this difficult. Pamela has a few words. You need to take your mic. Yeah.
Okay, so I just want to say that the New York Times has an excellent article on how critical race theory has become politicized. So anybody interested might want to check out that article. So Gideon, you've given us a lot to think about, a lot. And I believe even more now that your research project needs to be funded, and needs to be funded immediately, because what you describe is of critical current importance. Also, given, for those of us who work in anti-racism education, and I believe the center is a leading promoter and discussant of anti-racism, we have a lot to think about as we continue our work. Also, in thinking further of how facial recognition technology seems to target, my word, darker skinned folk, I'm wondering about the impact on not just people who describe themselves as Black, but people from places like India, Sri Lanka, and other places in the world from which we get refugees, immigrants, and how that might affect them, because it seems to target, as you've said, people with darker skins. And while I recognize that not everybody from those countries have darker skins, many do. So thanks again. and best wishes as you pursue funding for your research.
Thanks, Pamela. And I want to thank the Alberta Civil Liberties Research Center for giving me the opportunity. I mean, this is the first time I'm presenting this. So I'm in this research. So I still have a long way to go. And I'm looking forward to our partnership hopefully a partnership on this project to kind of research this issue further. So thank you very much for the invitation.
Thank you so much. And also, maybe another time, once you get into it more, we can invite you back to edify where you're at that point.
Okay.
Are you done, Pamela? I didn't want to interrupt you.
Yes, yeah, no, that's good. And by that time, we will be a partner, won't we?
Yes, we have to think positive. Absolutely. Absolutely. And as a side comment, and I don't know if this is going to be of any help, but my former research associate's husband is the current Minister of Immigration.
Absolutely, yeah.
So
yeah.
maybe I can get you in touch with him.
Okay.
We'll see. He's a very nice chap. I think he's got a lot on his plate right now. But
Yeah.
so hopefully, Sarah's husband, Sean Fraser.
Sean Fraser, exactly. That's
Yeah.
right.
So anyway, thank you so much and nice to see you. And I learned a lot. So thank you.
Thank you, everyone. Mhm.
Take care.